Hello, class. So we're gone through chapter 1, chapter 2, and chapter 3, and now we're going to start on chapter 4, civil liberties. So, again, we're going to start where what's the foundation for this chapter, what direction we're going in, and so we're going to trace the constitutional roots of our civil liberties. We're going to describe the First Amendment guarantees of freedom of religion. We're going to outline the First Amendment guarantees and limitations on speech, press, assembly, and petition. We'll summarize some changes that we've seen in certain amendments, such as the Second Amendment, because it's a very interesting amendment because it imbues rights to carry arms, but we didn't always give those rights to everyone. But the right is really strong, and we'll talk about the dynamics of that. And, we'll analyze the rights of criminal defendants found in the Bill of Rights. That's your fifth and parts of your fourth, your fifth, your sixth amendment, parts of your eighth amendment. The Ninth Amendment, which kind of is a catch-all. It's not really written out, but it's very important because it gives you rights that aren't written down here in the Bill of Rights. That's very important. And when we'll explain some origins and significance of the right to privacy, and we'll evaluate some reforms that have happened in civil liberties over time. So let's start on this chapter. So one of the first things we're going to want to know is what's the difference between a civil liberty and a civil right? Well, your civil liberties are your rights found in the Bill of Rights. And then your civil rights are all the rest of them that come after the first 10. So, and really it's the first 9, because remember the 10th Amendment talks about the rights that belong to the states. It's the rights that belong to the people in the states, but it's more of a foundation to the rights of the state. And so a lot of our understanding of our civil liberties comes through the first 9. And so your personal guarantees and freedoms that government cannot abridge is one of the definitions. So when we talk about civil liberties, your civil liberties are your rights against government infringement on you. Actually, vast majority of all of your civil liberties only apply between the relationship between you and government. One of the things that we hear people say all the time is they violated your freedom of speech. Well, people can violate your freedom of speech all the time because there's no protection there. Let me give you a great example. Facebook or TikTok or Instagram or any other type of social media gives you a free website that allows you to post whatever you want to post. Well, that's within reason. It's not whatever you want to post. I can't take a nude picture of someone or myself and post it to Facebook and expect Facebook to leave that up there. It's Facebook space, but they allow me to use that as I see fit and post that how I want to within reason. And that would be an infringement on my speech, but there's no protection there. Your civil liberties are only protections that exist between you and government. The rights that government cannot infringe upon. Those are your civil liberties. So you're right from government infringement. I think I want to clarify this slide, especially because I have your freedom to rights. Really, I want to flip-flop that. These are your freedoms from government interference in your everyday rights, or your most important rights. Compared to civil rights, those are your freedom to rights. I'm kind of flip-flopping what I have written down here because it's important for your understanding. Civil rights, your freedom to go to school, your freedom to get an education, your freedom to exist in a community without discrimination. Your civil rights are protection against government discrimination and personal discrimination from others. So civil liberties are freedom from government interference in your rights. Civil rights, freedoms from discrimination by government or other individuals. So another person can infringe on your civil rights, but another person can't infringe on your civil liberties. Now, they can violate you in a way that can closely resemble a violation of your civil rights. So, enslavement, when we pass the 13th Amendment comes into there, so, freedom against, that's a civil right. So again, when somebody enslaves you, again, that would be a violation of your civil rights. So somebody is trying to harm you, if we were to try to relate that to cruel and unusual punishment, that would be a violation of the law, but it's not a violation of your civil rights because, again, there's no authority they have over you to be able to create some sort of excessive punishment on you. So let's get into this. So when we have our civil liberties, we still have to ask these questions. Because again, these are rights that we've written down because at one point governments were taking these from us, and we felt that this was some of the most important things that we did not want government to do or to harm or to violate. And so we wrote them down as the first 10 amendments to the Bill of Rights and of our Constitution. But there's still some questions we want to have. So what boundaries do we want to give to people to be able to speak? Do we want people to be able to say anything they want without punishment? How much infringement on a personal liberties do we want to give police or government actors? Again, we don't want people to have complete freedom in their homes because, again, I don't want my next door neighbor, building a meth lab next door to me and blowing themselves up and possibly blowing me up. But again, I don't want police to be able to just walk into somebody's home and start checking their home just willy-nilly. So there's some lines that we're going to try to figure out. What liberties do we want to accord those who oppose war or suspected of anti-government activity? Again, we want people to be able to speak up against government action because we want to be able to challenge government when it's necessary. But we also don't want terrorist action. So there's some balance that belongs in this debate over civil liberties. Now, I'm actually going to skip this slide because we talked about the Federalists and a lot of the dynamics of the 10th Amendment in chapters 1 through 3. And so let's just stay on our civil liberties path. So the Bill of Rights is where our civil liberties are found. And it contains specific guarantees and rights in certain areas: speech, press, assembly, religion, the right to bear arms, infringement on your person when it comes to searches, self-incrimination, excessive punishments or cruel and unusual punishments. These are some of the things that come into play. And we also have kind of a catch-all in the 9th Amendment that says, that there are rights that belong to you that aren't written down in the Constitution. And probably the most pressing example of that is the right to privacy. The right to privacy we'll talk about later is a judicially created right. That means somebody challenged the Constitution over whether they had a right to privacy, and the court said, yes, you do, but it's not found in the Constitution. I've always said this, and when I'm teaching class in person, that if you can find in the Constitution where it says you have the right to privacy in the Constitution, where those words are found in the body of the Constitution or the subsequent Bill of Rights, I'll give you an automatic A for the course. And I'm willing to do that because it doesn't exist in the body of the Constitution nor the following amendments. And so those are some of the things that we have to understand and lay out, that there are rights that we have that aren't written down. And many of those rights are very important. The right to privacy is built out of parts of the first, the second, the third, the fourth, the fifth, the sixth, and then actually 1 through 9 all have parts that could be considered privacy. My ability to store my firearms, my ability to have a home that soldiers can't be placed in, my ability to be confident that my papers and other documents or other private matters can be held private. How I can protect myself and the information that I have to share with government and the information I don't have to share with government when it comes to being accused of a crime, and then going through the process of my guilt or innocence, what needs to be protected and what doesn't. These all are connected to your right to privacy, which is not a right that is written down in the Constitution. So let's start our conversation off with something that's actually not in the Bill of Rights, but is very closely related, and so we're going to begin here. So the 14th Amendment is part of the is part of our civil rights, but has an effect on our civil liberties. In understanding the 14th Amendment, I usually write it down, and because it has 4 parts, and these 4 parts are very important. And so we start off with the first part, which is due process. 14th Amendment covers your due process. Now, due process is interesting because it's found in 2 places in the Constitution. It's found in the 5th Amendment, which applies it to the federal government, and it is also found in the 14th Amendment, which applies it to everywhere. So when we talk about due process, there's 2 ways in which it can be applied. It can be applied only to the federal government through the 5th Amendment, or it can be applied universally through the 14th Amendment. And your due process clause, again, guarantees your life, liberty, and property. Now, some of you probably thought pursuit of happiness, but that's the Declaration of Independence. We're talking about the Constitution, the actual governing document of our nation. So the guarantees life, liberty, and property unless there is a hearing that removes those rights. Now, I, as a citizen, have my due process rights, and I have the right to live my life as I see fit, as long as I'm within the framework of the law. However, if I, harm someone and a hearing determines my guilt in harming someone, I can lose some of my rights, and I might lose some of my freedom. That's my liberty. And I might go to jail for a particular amount of time, or I might even go to prison for a particular amount of time because of my action. And so again, a due process clause guarantees life, liberty, the protection of life, liberty, and property unless there is a hearing, some sort of judicial proceeding that removes those rights. Our next part of the 14th Amendment, which is actually going to apply more to our civil liberties, is our incorporation clause, which applies the Bill of Rights to the states. Now, when I make this note for myself, I always write in part. In part. All right, in part. Sorry if you see me looking down. My dog is sitting down here. He's getting up and laying down, so I just want to check in on him. In part, because in the beginning, our Bill of Rights do not apply to the states. So in the beginning, states could infringe on all your civil liberties as they saw fit. There was no freedom of speech. There was no freedom of the press. There was no freedom of religion. There was no, protection against cruel and unusual punishment or search and seizure if the state didn't give you that protection. And actually, even though the federal government has mandated that states have to give you some of these protections, not all the protections found in the civil and the Bill of Rights are protected by the states. Some states do not have a protection against excessive fines or bails. That's part of the 8th Amendment. And so if a state wanted to lobby a bail of $1 million or $2 million on an individual, and there's no protection in their state constitution to protect you from that, you might be affected. Here in the state of Georgia, we don't have here in the state of Georgia, we have that protection under Georgia's constitution protects you from excessive fines or bails, which is nice. But depending on the state that you live in, you might not have that protection. The third part of the 14th Amendment is substantive due process. The substantive due process is actually a power given to our Supreme Court. It allows the Supreme Court to interpret the law. So many of you are going to say, well, isn't that what judicial review is? Isn't that the power of the court? Well, a lot of times our court has the ability to interpret things. The wording of the Constitution does not change, but how the Constitution applies changes. Again, I talked about the Second Amendment right to bear arms. The wording of the Second Amendment right to bear arms has never changed in the United States, but how it is applied has surely changed, depending on your gender, depending on your race, depending on your former slave status. You may not have been able to have a firearm, but the Constitution of the United States during that time said that you had that right, but it didn't apply to you. Maybe you were a female, maybe you were a minority, maybe you were a former slave. But the wording didn't change. But over time, through judicial interpretation, we do see changes in how that is understood. And so that would be an example of a judicial interpretation or substantive due process in action. And the last but not least is the Equal Protection Clause. Again, everyone is equal in the eyes of the law. Everyone is equal in the eyes of the law. So again, our four parts of our 14th Amendment The Due Process Clause guarantees life, liberty, and property unless there is a judicial hearing that removes those rights. The Incorporation Clause applies the Bill of Rights to the states in part. Again, not all of our Bill of Rights, even today, are applied to the states. And in the beginning, the Bill of Rights did not apply to the states. Substantive due process allows the Supreme Court to interpret the law. And Equal Protection Clause, everyone is equal in the eyes of the law. So that's where we are. That's where we are. So let's look at our Bill of Rights, because again, there are 10 of them, but there's a lot of things that are covered under our Bill of Rights in our civil liberties. The First Amendment has 4 main areas: speech, press, assembly, religion. The Second Amendment, right to bear arms. The Third Amendment, no quartering of soldiers. The Fourth Amendment, no unreasonable searches and seizures, and also covers the exclusionary rule, which stops government from using illegally seized evidence to prosecute you. The Fifth Amendment, just compensation, self-incrimination, double jeopardy, grand jury indictments. The Sixth Amendment, right to counsel, public trial, confrontation of witnesses, impartial trial, speedy trial, compulsory trial. Compulsory means that you have to have a trial. And criminal trial. Seventh Amendment, civil jury trial. Eighth Amendment, no cruel and unusual punishment or no excessive fines and bails. And Ninth Amendment, which is actually not on this chart, that there are rights that belong to you as an American citizen or as a person in America that are not necessarily written down in these rights. So again, now, if you look at this chart, you're going to see that some of these cases say not incorporated. That means they're not applied to the state. So Third Amendment, no quartering of soldiers, not applied to the states. Grand jury indictment, so you have that protection here in the state of Georgia if you live here in Georgia. But if a crime is going to be brought against you, if you're going to be charged with a crime, evidence has to be gathered. It's brought up to a group of people called a grand jury, and they're going to vote to determine if the municipality that you live in, where you live in, or the jurisdiction that you live in, is going to bring charges against you. And then we have also civil jury trial is not incorporated. Again, in many instances, you have to pay for a jury trial. In most states, if you want one, most times judges are in civil cases. Judges are the ones who are going to be the arbitrators and make the decision there. And again, no excessive fines or bails. That's not incorporated in many states, just depending on where you live. So let's talk about this. Remember, in the beginning, the Bill of Rights does not apply to the states. So a lot of the protections that we know of today are not there for citizens in the early 1800s and the early 1900s, especially the early, many in the early 1800s. Much of this didn't apply to, 1850 is the earliest that any of this applies. And so we're going to see that in the early 1900s, this century, because we're in a new century, just the beginning of last century, though less than 100 years ago, many of the rights that we take for granted in our civil liberties are going to be applied. So I love talking about cases. Again, I will tell you the cases for your exam that you're going to be paying the most attention to. But again, it allows me to tell stories, and I love to tell stories. So, Gitlow versus New York, 1925 case. This is an issue of sedition laws. Sedition is speaking out against the government, saying unfavorable things about your government. That is sedition. And so it is illegal under New York law to speak out politically against the government. This is actually has a name. It's sedition. But the act of stopping somebody from speaking out against the government and punishing people who are trying to do so prior to them making the speech is called prior restraint. When you restrain or make a law that says you cannot do something before it happens, or you're going to punish an action before it happens, that's called prior restraint, and that's unconstitutional. So Gitlow lived in New York, and he's unhappy with how workers are treated. He's unhappy about how government is acting, and he prints out 16,000 manifestos that urge workers to overthrow the government. And he was arrested. He gets them printed. He has them in boxes. He's pushing them down the road in this cart. and he gets stopped. Well, he's on the sidewalk, gets stopped by two police officers, and they ask him about his what's he got in the boxes, and he's like, I don't have anything in the boxes. And they're like, well, no, obviously you have something in the boxes, and he knows whether know your business. And so they go through his boxes, and they see that he has these manifestos that say, "Workers unite, overthrow the government," and he's arrested. But the question we have to ask, and the question the Supreme Court has to ask is, has Gitlow done anything yet? Has he done anything? Have they been distributed? Well, at this point, no. And has anybody read them? Well, outside the officers who he kind of violated his Fourth Amendment right, and again, the Fourth Amendment doesn't apply yet, he really hasn't done anything yet. So at this point, the documents are his thoughts. And we're all privy to our thoughts. Your thoughts are something that cannot be infringed upon. They're in your head or they're written down as long as you don't broadcast them. And so the Supreme Court rules that states were not completely free to limit forms of political expression because there are some fundamental rights and liberties that exist that we all have and cannot be infringed upon. And at this point in time, the Supreme Court says, through the 14th Amendment, we're going to say that certain parts of our Bill of Rights are going to be protected from state intervention as well. And so this is not just speech at this point. These are our fundamental freedoms, which is pretty much everything that falls in the First Amendment: your speech, your press, your assembly, and your religion. That's where we are. So your speech, your press, your assembly, and your religion. So that's all we're really talking about now. So Gitlow establishes that there are some rights that you have. Our Supreme Court narrows them and lets us know what this is. And at the beginning, it's your speech, your press, your assembly, and your religion. This at this time is going to be known as, and this still is known as today, selective incorporation. That is applying some of the Bill of Rights to the states. So we're selectively saying that some of the Bill of Rights applies to both the national government and the states, because not all parts and all the protections apply to both. So let's give an example of this. So Palco versus Connecticut. Palco is charged with the first-degree murder of two police officers, was found guilty of the lesser charge of second-degree murder. Palco, I can't remember exactly what Palco was doing. I think he was, in the process of robbing something, and during that time, he comes across these officers, and in their scuffle, he ends up killing these two officers. And Palco was found guilty of the lesser charge of second-degree murder. And murder works in a particular way. Murder has hierarchies. At the top, you have first-degree murder, then you have second-degree murder, then you have manslaughter, and then you have involuntary manslaughter. They're all parts of the same act. The lower tier, so your involuntary manslaughter, your manslaughter, and your second-degree murder, all of those elements are going to be found in first-degree murder. So your involuntary manslaughter is causing the accidental causing of a death of another. It's the same as so say I'm on a roof of my house redoing my roof, and I carry all my tools up to my roof, and at the end of the day when I'm done with my roof, I start, instead of taking my tools down, I just throw them off the side of my roof, and I don't realize that my neighbor's coming over to check on me. They notice I've been up on my roof all day, and they know I'm hot. They bring me some water, but at that time I throw my hammer off the roof, and it hits them in the head, and they die. And so I know better. I should know better than to throw my tools off the side of my house, because somebody could be down there. So my negligent action caused the death of another. That's involuntary manslaughter. You're not trying to kill somebody, but your negligent act led to their death. And that would be involuntary manslaughter. Manslaughter is the killing of another. Your action, your non-negligent action, you are doing something that you're supposed to be doing, led to the death of another. So probably the most recent example that a lot of people give manslaughter now is texting and driving. Your illegal action led to the death of another. Now, your action normally wouldn't lead to someone's death, but say I'm driving through the parking lot of my school and I'm texting on my phone and I don't realize a student is crossing to their car, and I'm flying through the parking lot texting on my phone, and I run them over and they die. Again, I'm not supposed to be texting and driving. That's an illegal action that led to the death of another person. That would be manslaughter. Again, in some instances, you might even get more than that, depending on how somebody would charge you. Second degree murder, the purposeful killing of another person. So second degree murder means you killed them on purpose. You might not have planned it, which is going to be what the level for first degree murder is. And so so say I'm walking out to my car and I have an arch enemy that we get in arguments all the time. And during one of our spats, we start fighting. And in the middle of that fight, I just escalate it and I kill them. Well, again, my action of fighting them is purposeful. And I escalated it to another level and I take their life. That would be second degree murder. And then again, first degree murder, the planned killing of somebody. I put together the pieces and premeditate or have malice aforethought is what the old common law definition was. That I think out a way of killing somebody and I go out of my way to act out those actions to take their life. That is malice aforethought or premeditation, and that's first degree murder. So in Paulko's instance, he wasn't planning to kill these police officers, and the jury comes back and finds him guilty of second degree murder, which again, if you're not found guilty of first degree, you can be found guilty of second degree. These are lesser included offenses. The first degree, the elements of involuntary manslaughter are found in manslaughter. The elements of manslaughter are found in second degree murder. The elements of second degree murder are found in first degree murder. So if you're not found guilty of first degree murder, you can be found guilty of second degree. If you're not found guilty of second degree, you can still be found guilty of manslaughter. If you're not found guilty of manslaughter, you still can be found guilty of involuntary manslaughter. And so that's why they're called lesser included offenses. It's like a step where you can step up in the elements and also step down in how you can find someone guilty. And so they're found guilty of second degree. He's found guilty of second degree murder. The state of Connecticut wants to make an example of Paulko because it doesn't want anybody killing their police officers, which makes sense. But they're going to try him again. And you and I would know this as double jeopardy. And it is. However, at this time, the protection of double jeopardy does not apply to the state of Connecticut or any state at this time. Paulko is retried. He's found guilty of first degree murder. And the reason they want to find him guilty of first degree murder is they want to put him to death. And so that's how this works. Because it's not a fundamental freedom. It's not speech, press, assembly, or religion, or the things found under our foreign fundamental freedoms. It did not apply during this time due to selective incorporation. Now, selective incorporation today is far expanded, and this does apply today. So let's start with our First Amendment. We're actually going to spend the vast majority of our time here. Our First Amendment imposes a number of restrictions on the federal government relating to civil liberties, including religion, speech, press, and assembly. Congress, we'll start with religion. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. This is two separate clauses that we find in our First Amendment when it comes to religion. So first, we have the Establishment Clause. Directs the national government to not to sanction or create a official religion. So there's no official religion for the United States. We are a Protestant nation by heritage, a Protestant Christian nation. So Christianity is the backbone religion of our nation, but it's not an official religion of our nation. So a lot of Christianity floods into how we do laws and other things in our society, but there's no official religion in our society. Born out of the Establishment Clause is the separation of church and state. Many people ask that question. Well, where does the separation of church and state come from? Well, it's born out of the Establishment Clause, which says, well, there's no official religion. And so we've decided over time that we're going to separate some aspects of government and some aspects of our religion because there's people with other religions. And some of the aspects of religion don't always jive with how we want to govern. And then the Free Exercise Clause. It prohibits the United States government from interfering with a citizen's right to practice his or her religion. But that's not absolute. Depending on who you are, or depending on the type of religion, or depending on the act, you might not have the full means to interact or do your religious action. So when it comes to faith, Hold on 1 second. I'm about to put him out. Give it a quick second. Come here, Zulu. Come on, outside. We're snoring. Go on, buddy. Go on, lay down. Out there snoring. Over there snoring. All right. So when it comes to faith, there's some interesting understandings. I may be able to believe something, and you're completely free to believe whatever you want, but I might not be able to put my faith into action all the time. That's what the free exercise clause says. You're able to believe what you want to believe, but putting it into action can create some problems. And some of you are going to say, well, how is that? Well, if I'm a descendant of the Aztecs and I want to sacrifice a still living human being to my religious deity or my God, I can't do such. I can believe it all day, but I can't, capture somebody and then cut out their still beating heart and sacrifice it to the sun god, if that's what my faith is. Again, when you talk about many rights, this is kind of very important. Your right ends where somebody else's right begins, or it breaks the law. I'll say it again. Your right ends where somebody else's right begins, or it breaks the law. So again, taking somebody's life, even if they want me to take it, is murder. So that you can't purposely give up your life in most instances in the United States. There are some states that allow you to do that when it comes to being terminally ill, but you cannot give up your life. You can't allow somebody to murder you, even if you both believe the same thing. That would be a violation of the law, and your belief does not extend to that. Again, when it gets into actions, and we'll talk about this more when we talk about speech, and we'll talk about symbolic speech. When it comes to actions, there are certain actions that you cannot do. Government can regulate your actions, but you can believe whatever you want to believe. Or say I'm a descendant of, I'm born in Haiti, and I'm born in, I can be born in Haiti or Jamaica, and I'm Rastafarian, and as my religion. And one of the things that I believe is to get closer to God, we use certain herbs, and usually it would be marijuana to get high, to get closer to God. Well, if I grew up in that culture, I might have a better argument. But if I just all of a sudden here in the United States today, at 37 years old, I decide to convert to Rastafarianism, and part of that is I believe that I should be able to get high to get closer to God. If I'm in a state that does not allow the use of marijuana recreationally, I cannot do that. It's a violation of the law, and you're not protected under the free exercise clause. Those are the examples. There's some examples. We've seen it with Native Americans. They might be able to use peyote in some instances, even though other people might not be able to, as a means of getting closer to God. There again, depending on certain context, it might be easier for you to argue legally for some than others. So, religion when it comes to schools or government. So when we talk about religion and government and how they intertwine, there are certain aspects of it, and especially we see it in school, where we try to balance out what is allowable and what is not. And so the court has held fast of a rule of strict separation between church and state. Engel versus Vital, recitation in public school classroom of a brief non-denominational prayer or prayer drafted by local school district was unconstitutional. I teach a lot of school, teach a lot of dual enrollment things and dual enrollment classes. So keep this in mind. Where I live in Georgia is far more reverent than many other places I've lived. I've lived in Tennessee, which is really reverent as well. But I've also lived in Michigan and Illinois. And so the application of how our lives are a little bit different depending on where you live in the country. And so some people are a little bit more religious in certain areas, and some people are a little bit more secular, meaning that the citizenry of non-religious has a large say. So depending on where you live, you might see some of these actions and say, hey, we do those things. Are they unconstitutional? They may be unconstitutional, but because the religious background in your area is really strong, you might still see them done in your school. So that still might exist, but I'm not trying to advocate anybody causing an uprising in any school. But again, recitation of public school classroom of brief non-denominational prayer or prayer drafted by local school district was unconstitutional. Well, why? One, it highlights one religion over the other, and again, government can't sanction one religion over the other. And also, it doesn't matter who is the originator. If it's, especially if it's the teacher. So if your teacher and you're in a public school and your teacher says we're going to pray, it's the government sanctioning that behavior. Your teacher's a government actor and they're sanctioning that behavior. And again, you're highlighting one religion over the other as a practice. And again, the lack of faith is kind of a faith. So there are certain aspects of that come into play as well. If we were to, let's say, hey, a moment of silence. Many people ask me about that all the time. A moment of silence. What is a moment of silence? Isn't that prayer? Well, no. If we take a moment of silence, and let's take one now. So in that time, what was I doing? I could have been praying. I may not have been praying. I could have been thinking about what I have to do for the rest of the day. I could have been thinking about nothing. So because nothing is broadcast, government doesn't have the right to regulate. So again, a lot of when it comes to speech, and your faith in many times has to be spoken, has to be expressed. A lot of times when it comes to speech, government has no ability to act if nothing is broadcast. Get Low is a great example of that. Was anything broadcast? Well, no, he hadn't handed out his paper. He hadn't put him up on the walls anywhere. He hadn't put it out for people to see. And because he hadn't done so, the government did not have the right to regulate. Once you broadcast, government has the right to regulate. So Get Low hasn't broadcast, so government couldn't regulate his behavior until once he starts handing out those papers, those police could talk to him and say, hey, you're not supposed to do that, and then that would be a different story. Prior to that, punishing him before the hand would be prior restraint, which is unconstitutional. Government does not have that behavior. But once you broadcast your speech, or once you broadcast your prayer, or once you broadcast whatever you're trying to say, now it becomes words, and government has the right to regulate. So again, say if it's not the teacher, say if it's another student in your class, and they say, hey, I want to stand up and we're all going to pray. And that also is a violation of the Constitution. It's unconstitutional. Well, why? Because allowing it as a teacher would be, and again, this is not my personal belief, this is the argument that's been made in the country. So it may be my personal belief, it may not be, but this is the argument that's made constitutionally. If the teacher allows that broadcast, you are favoring one religion over the other. You're saying, okay, well, this is allowable broadcast in my classroom. And so you're sanctioning that behavior, and that would be government. You as a teacher or an actor of government, that would be government approving that behavior. I always say this to my class. I said, if I was teaching your class and all of a sudden one of your fellow students stood up and stripped down naked and just started running around in circles around the room, and I'm your teacher and I say nothing, it's pretty much me approving that behavior. And so this falls into that same category. You're approving that behavior if nothing is said about it or is not admonished. And so those are the things that come into play. Abington School District versus Shemp. Again, state mandated Bible reading or recitation of the Lord's Prayer in public schools is unconstitutional. Again, government is promoting something, or even if an individual promotes something. There is a test to determine how much religion is allowable in something. It's called the Lemon test. I used to test on that. I really don't anymore, but it creates a 3-tier dynamic. If it's something religious that's happening and it's intertwined with government, must have like a legitimate secular purpose, meaning a non-religious purpose, must neither advance nor inhibit religion, and does not foster an excessive government entanglement of religion. I remember when I was in school, I think I was in the 4th grade, we were doing countries around America was our assignment, and every class was assigned a country. And, you were learning about that country, and you learned about other countries, but there was a main country that you learned about, and you were supposed to do holidays around the world. And so we had Israel. And so we had Hanukkah as our holiday around the world, and Hanukkah is a religious holiday, being their main holiday in that country. And it was our job to present that. And so there was it was a religious holiday, and it was expressed. But it didn't have an overarching entanglement, and many people had other countries, and they had different holidays, and many of those holidays were non-religious. And so it wasn't an excessive entanglement, which means it was allowable. Christian Legal Society versus Martinez. It states that a religious-based group within a school can exist as long as it doesn't limit its its members to only faith-based believers, meaning that if somebody who is not a member of that faith wants to be a member of your group, you can't deny them. And so that's the one of the things. So you can't deny somebody if you have a fellowship of Christian athletes and somebody wants to join the group that's not a Christian. Yeah, and one, if you're a group of Christians and somebody wants to come in that's not a Christian, it's probably a good thing. So maybe you can convert them. But this is saying if somebody wants to be a member of the group and they're not, you can't say, well, no, you're not. No, you don't fall under the criteria of what we are. You can't be a member of the group. And so it says these groups are allowable as long as they don't limit their membership to only faith-based believers. And so you see that's probably one of the more prominent religious-based groups that we see in public schools or Fellowship of Christian Athletes, and that's why they can exist, because again, as long as they don't limit their membership to only faith-based believers, it's fine. And again, free exercise clause. Congress shall make no law prohibiting the free exercise of religion. Again, promises but does not guarantee individuals the right to be free from government interference in their belief or exercise of religion. So again, you can believe what you want to believe, but when it comes to the exercising of it, if it breaks the law or if it clashes with somebody else's rights, there probably going to be limits. So that's religion. Let's get into the speech aspect. And again, a lot of our speech aspects still religious aspect covered parts of speech. So the First Amendment covers our freedom of speech, press, assembly, and petition. When we talk about speech, Congress shall make no law abridging the freedom of speech or of the press. So we'll talk about speech, and then we'll talk about the aspects of the press as well. But speech is kind of broken down. It's given protections differently depending on how the speech is done. The most protection that is given to your thoughts. Your thoughts are something that's not broadcast or either in your head or written down and not shared. Unshared speech are your thoughts that has the most protection, and you pretty much can think anything you want, and government has no ability to regulate because, again, it is not broadcast. The moment that you broadcast it and turn it into words or some sort of expression, government has the right to regulate under the law. So again, once I say something about, out in the world and it becomes broadcast, like I am now, I'm broadcasting this to you. If I did something obscene or, outside the realm of what is appropriate, it could be regulated by government. And then the least amount of protection is given to your actions. Again, once you do something into actions, it can cause harm to others. Again, your words can cause harm, but actions have an ability to cause more harm than just the words themselves. And so it's given the least amount of protection. An action can, be physical or cause, a physical change to something in existence, and so it's given the least amount of protection. There are times in history, though, that we've suspended some of our freedoms of speech, and we've gone back and determined that those aspects have been unconstitutional. But during those times, when people are fearful, we see a lot of time that we allow those things to happen. Alien and Sedition Acts, that is a type of prior restraint. You cannot speak out against a particular war or what's going on in government. It is a constitutional doctrine that prevents the government from governments from. Oh, excuse me. I have the definition for prior restraint up here. Again, prior restraint. This is an example of prior restraint. Constitutional doctrine that prevents